Denise Howell here, and next up on This Week in Law, we look at the state of privacy and the social network, Facebook, of course. Marty Schwimmer comes along to talk about ACTA, COICA, and his most valuable piece of legal advice ever. We're also joined by Evan Brown and Karl Susman. Stay tuned for all this and more next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law, episode 81, Egg-Laying Platypi. This episode of This Week in Law is brought to you by Hover.com. Hover is domain registration and management that's simple. For 10% off your new domain, go to twil.hover.com. Hello, relax. You've made it. You're here for your weekly interlude of internet and technology law, This Week in Law. You're here with our fabulous panel, which this week includes Karl.
Hello.
Susman, gadget guy here in Southern California. You find time somehow to sell insurance as well, which is both podcast and blogger friendly, which makes it quite an interesting line of work. And also very active on Twitter and constantly sending me great links for the show. So I'm thrilled to have you back on. Thanks for coming.
I'm your personal RSS feed. What can I tell you? If I see something law related, I think, she has to see this right away.
You are. You're my push. You send it all my way, and I love it. Thanks. And also joining us, taking time out from his busy law practice with Moses and Singer in New York, is Marty Schwimmer. Welcome back,
Hi,
Marty.
Denise.
Marty, of course, is the author of the Trademark blog, trademark lawyer extraordinaire, lover of all things Monty Python, and general all-around great guy. Thanks so much for coming back on the show.
Good to be here, Denise.
Wonderful to have you. And, of course, my partner in crime, my weekly commentator on all things net law related, Evan Brown from Chicago, the law firm of Hinshaw and Culbertson, and the blog at internetcases.com. Thanks for joining us, Evan.
Yes, it's great to be here as usual. It's going to be a wonderful time today. Good to see you, Marty, and good to see you, Karl. It's going to be a fun time.
It is. So I wanted to lead off with a number of stories around one of our favorite platforms to talk about, and that being Facebook. Seems like a lot of things that cropped up this week either indirectly or directly involved Facebook. So let's use that as our touchstone for the first few stories. First, very sadly, we have not yet chatted about Tyler Clementi. The connection to Facebook there is fairly tenuous, although except as the punctuation at the end of the story when Tyler, a student at Rutgers, I believe, updated his status there to inform people that he was going to jump off the George Washington Bridge in light of the traumatic things that had happened to him. And Karl, you had suggested that we talk about this. I wasn't going to put it in the show to begin with, but I'm glad you brought it up. Because it is obviously an important issue. And I think it's worth discussing whether this was a failure of technology, law, and policy, or whether instead it was a failure of, obviously good judgment and kindness and consideration on some people's parts. And also perhaps the policies within the university that matched these people up as roommates and didn't adequately... Sorry. Let me just finish the sentence.
It's my fault. Yeah.
Didn't adequately, address the situation as it was unfolding. So, Karl, why don't you tell us the technology at issue here, where, let me just give people some backdrop. I'm assuming a lot of people have heard the story, but if not, The lead up to Tyler's suicide had to do with his roommate allegedly capturing and streaming some of Tyler's sexual encounters with another man, that he used iChat to distribute this to whoever wanted to tune in. And he used Twitter to advise people that this video was going to be available. Again, all of this is subject to allegation and investigation. We don't know, exactly what happened here, but this is the story as it's unfolding. Karl, do you think that really this is a technology issue or a societal issue?
Sorry first for interrupting. Of course, I usually have great bandwidth, and for some reason this morning I've got a 3 or 4 second delay, so I feel like I'm talking to you from Hong Kong or something. So if I'm slower than usual on the response, that's probably why. What's interesting about this story is it actually kind of flew under the radar for me initially, and then of course all of my close friends and family start sending me links saying, "Aha, you see, this is the internet, this is Facebook, this is privacy, this is why everything is so bad," because in my circle, it's all because of me that these things exist, apparently. And I started reading it and thinking about it, and I realized that, this has really very little to do with Facebook or privacy. This could be this is no different than back when we were all younger. Maybe you'd play a joke on someone, you'd record a conversation over the phone with them, you'd pass it along. I actually heard an interesting story. It was on... what's that podcast? Fresh Air. This American Life. And it was about a college that had a voicemail system where the voicemails were kept and could be forwarded around. And someone had left the voicemail that was a little bit embarrassing, and it was forwarded on to everybody in the school, and it was this whole big to-do. And at the end of the day, it all comes down to the people's individual behaviors and what they do versus how bad privacy is with Facebook, or how much... or how quickly you can, damage somebody's reputation or hurt them. It's obviously a horrible thing that happened, but I'm having a really hard time making this be about the evils of Facebook.
Yeah, as am I. What do you think, Evan? Is this something where the technology is just sort of in the background of what actually happened here, and it's something that we're just going to have to get used to, that technology will be in the background of these sorts of things?
I think that it played a little bit more than just a background role in this. No doubt it's a human story, and it's a human drama. This kid, was really embarrassed by what had happened. I guess he was embarrassed. For whatever reason, he was so despondent to commit suicide. Technology is not completely irrelevant to all of this, to this story, though, because I think we would be a bit naive to think that because of the fact that this was broadcast, and nobody knows how extensively it was broadcast, but because it was made the subject of an iChat session and was advertised, so to speak, on Twitter, and because this Tyler guy had gone onto forums and on Facebook to communicate about all of this, the broader context afforded this story, because of technology, had to have played a role into the magnitude of the despondency that this poor guy felt. And for that reason, technology played more than just a tangential or marginal role in all of this. Also, technology seems to be playing a role in the investigation here, or at least the laws and the policies set up around the use of this technology. We've got the investigation now going on by the county district attorney's office, and I think this is the article that Karl may have sent in to you. There appears to be some difficulty, or at least some resistance on the part of the university in being forthcoming and disclosing email communications in connection with the investigation of what went on, or at least what went on in the among the staff of the university in handling these complaints that we'll just call them the victim here made beforehand. But it appears that the source of that resistance is the school's desire to comply with FERPA, the Federal Educational Rights and Privacy Act, which puts some constraints, I would assume, in addition to the Stored Communications Act, into how forthcoming the university can be in all of the investigation here. So, it's not as clear-cut of a technology and legal story as many of the other things we talk about on here, but the involvement of the web and the communications and the ability for it to be expanded so greatly definitely is a very strong catalyst in it all.
So, Marty, the drumbeat in the wake of all this has been tightening up and a push by a lot of politicians who know that this is a hot-button issue for their constituents to expand or enact cyberbullying laws. Do you think that that's an appropriate response here? Is that, lighting the torches or using this as an excuse to light the torches without much justification?
Well, I don't know. Maybe there should be a law that politicians are not allowed to discuss this sort of story until 1 year has passed once they move from the headlines, so we don't have knee-jerk reactions. I have no special insight into this story, and as you folks are talking, I'm thinking the underlying dynamics are clearly human. Why this act was a source of gossip, why the response was one of shame, assuming that we have the correct version of the story. But I am thinking, as Evan was talking, it might be the case that but for the technology, this response would not have been as drastic. So, for example, if the roommate had merely barged in, seen something, and then gossiped about it extensively, perhaps the shame would not have been as great as the perception that this had been broadcast to an infinite number of strangers. So I guess this is a situation where technology exacerbated already existing poor behavior, again, assuming that we have the facts right. But what does this mean? I mean, maybe we should not have webcams in our bedrooms. Maybe that's the proper response, not anything that a politician can do for us.
Right. I don't know if you'd be able to get that by some sort of university policy board that students would have to leave their webcams off campus.
If I could ask quickly, I'm sorry, Marty, I wanted to ask you because you, or either of you actually, legally speaking, one of the directions that there's been discussion about on this is moving this sort of up to the level of a hate crime. And I'm just curious what, legally speaking, what all of your opinions are as far as you see this as being something that would qualify to be characterized as a hate crime?
Well, none of us are criminal lawyers, so that's our first stumbling block to answer you that question. I do believe that is why the investigation is going forward to, for the authorities to decide what is the appropriate charge here, if any. Any further thoughts on this, Evan?
The question of whether hate crimes should even exist as a separate category is just one of those really difficult questions in law and policy and society. One of those things that should be on the list of topics you shouldn't bring up at a cocktail party along with religion, because it's just such an inherently ambiguous question. Clearly, there are important interests at stake in enhancing the culpability or in making these types of crimes more severely punishable. So I would just defer that into this broader discussion of whether and to what extent it's appropriate to punish these so-called hate crimes, however they may be defined in the first place. And it's a tough one, far beyond my poor power to try to adequately engage.
The tragedy of this is, well, obviously there's a lot of elements of tragedy to this, but one of them is that if Tyler had gone, instead of, trying to work through simply with his university, change roommates and what have you, if he had gone to the authorities, I think there would have been some relief for what happened here, be it hate crime charges or invasion of privacy charges. What we're talking about here is potentially the basis for a crime that could have given him some redress, or there would have been potentially civil remedies too. Now, obviously, a college student may not have the resources to think about launching a lawsuit against his roommate, but it's not like he did not have channels of redress here, short of jumping off a bridge. And the other thing that I would throw out is, before people get too anxious to indict the sort of ubiquitous technology in our life for playing a role in this kind of event, the ubiquitous technology in our life could have played a really ameliorative role here too, in that, Tyler already was communicating with people, in the reports I've read anyway, about what had happened, and was looking for support in online community kind of settings. And if you hunt around Facebook for support for these kinds of situations, you're going to find all kinds of it. On CBS News Sunday Morning last week, when this was first coming to light, they highlighted an organization called To Write Love on Her Arms, which has a big presence on Facebook and its own site, et cetera, which is a suicide prevention program aimed at college kids that is using technology squarely to get at people like Tyler. Unfortunately, it doesn't sound like they or anyone else was able to make a connection with him and have any sort of benefit. Marty, any last thoughts?
No.
Okay, so we're very, very sorry about what happened to Tyler, and hope that the authorities do get to the bottom of what exactly did happen and how the ball was dropped, because it appears that it was in some way or another, and there should be some sort of ramification. I don't know if we have to, revamp the entire legal system to address these sorts of situations. I do think that Marty's comment about, considering these issues not in the heat and aftermath of a tragic event is a good way to go about it.
I know you're wanting to move on, but let me make just one final observation. You got me thinking along these lines when you were saying what kind of redress he might have had, and I was reminded of a case from 2005 here in the Seventh Circuit called Doe versus Smith, and this was essentially a little bit similar to this factually. It was, I guess, a guy and a girl were, fooling around, and the boyfriend videotaped this, with a hidden camera, and distributed it by email. And the question was whether or not that was a violation of the Electronic Communications Privacy Act. The district court dismissed that, saying that it wasn't an interception, or they hadn't adequately pleaded that it was an interception within the meaning of the Electronic Communications Privacy Act. And that was reversed. Judge Easterbrook in the Seventh Circuit here reversed that, finding that there could be an interception of a communication, when you are filming yourself communicating with someone else. So interestingly enough, one of the dispositive facts on whether there'd be an Electronic Communications Privacy Act violation is whether there were any words exchanged between the participants in the subject matter being filmed. So factually, this is not the first time something at least related like this has happened. Yep, and it's just too bad that as someone is reeling from having gone through an experience like this, thinking about things rationally and the fact that the law might help them is probably not their first response. And emotion tends to take over, and, that's where people near them need to play the largest role. So let's talk about something a bit more lighthearted. I haven't gotten to see it yet, but The Social Network has come onto the scene, and in fact, a girlfriend of mine has kindly volunteered to watch my son this afternoon, so maybe I can sneak out and catch it. Nice. All right, well, we can still talk about it because there's a wonderful post over at Eric Gardner's The Hollywood Reporter Esquire blog, unpacking all the legal issues of the film. And I understand that the film takes place, a lot of it takes place in mediation rooms.
And also that, of course, it goes into the disputes between Mark Zuckerberg and the other people that were involved at the beginning of Facebook. So, Evan, what do you think of the legal issues in the film?
I haven't seen the film yet, but everybody who I've talked to who has seen it, really loves it. I've even there's a guy here in our office who went to Harvard, so he especially likes it. So for obvious reasons, a lot of it taking place there. So this is a neat story on the Hollywood Reporter. It was a guest post by a lawyer, Aaron Moss, at Greenberg Glusker in L.A., and he does a nice rundown of some of the things that you might expect, and does a comparison and analysis looking at other situations where there have been lawsuits for things like defamation and invasion of privacy that arise from portrayals of characters in movies like this. And so it really underscores and brings to light some of these questions that we talk about a lot, how a plaintiff should behave responsibly when considering to bring legal action against something that they find offensive that's either been said about them in some form of media. We're usually talking about it in terms of like a forum board comment or something on Yelp or something like that. But it really is a fine line, and there are not only the legal aspects of considering whether or not there really is like for example, looking at whether there's a misappropriation of the right of publicity here. It's a tricky question as to whether the portrayal would be a commercial use of one's name, image, or persona. In the context of defamation, it's a very unclear answer sometimes. Is a portrayal of a certain character really of or concerning that party? And so it can be a real challenge to figure out what the right thing to do, what the responsible thing for a person to do in considering the kind of action they should take if they feel that they've been mistreated in some way in some form of media like this. So it's a great rundown. This article is a great rundown of those issues, and is a good education on the various types of things that could arise in a situation like this.
Right. We're all used to seeing at the beginning of sometimes films, but most often books, the big disclaimer that, no character in this story is supposed to resemble any other person, any real person, living or dead, et cetera, et cetera. Can't say that about The Social Network at all. So there's perhaps something to talk about on Mark Zuckerberg's standpoint, from his standpoint. But Marty, do you think he'd ever really sue? And if he did, would there be anything for him to go after?
Well, Zuckerberg is fairly obviously a public figure, and therefore, as a plaintiff, he'd have to meet the highest level. In other words, that the movie makers had malice in the way in which they portrayed it, and that's a legal meaning of malice. It doesn't mean that Sorkin didn't like him and had a negative portrayal. So, as a matter of defamation, I think the consensus is that because of that high standard of his being a public figure, it'd be pretty hard for him to prevail.
I'm really surprised, Karl, you haven't seen the movie yet?
No, that's the funny thing, and I'm really getting a hard time because a good friend of mine works on the Red Camera, and this film was actually made on the Red Camera, so I've been hearing about this for a long, long time. I'm hoping to get out and see it this week, but I was thinking the same thing as I'm reading about it. However much of this might be fiction, what happens to some of these people? Forget the main character, forget Mark himself. But what about some of the other people, like his girlfriend, I understand, is supposedly not put out in the best actual light in this. And apparently they're still very close. They're still together. What if someone like that, she's clearly not a public figure, would she have any recourse? Is that something you could see as someone like her going out and saying, you know what, I'm not in this for the money. I did not, leave him, blah, blah, blah. Or is that...
Yeah.
I mean,
it seems to me as something that is potentially damaging to her reputation to portray her in that light. And
Aaron brings up an interesting point in this article. It's real tricky proposition to prove that you are so much like the character portrayed, that somebody is going to think that the statement is about you, while at the same time proving that you are so dislike that character that it's harmful to your reputation. It's a real double-edged sword, or a real kind of, medicine man speak with forked tongue. You got to say two different things at the same time that may be internally contradictory to one another. As for the girlfriend, and again, here we are talking about the movie, and I don't think any of us have seen it. But from what
that never stops us, Evan.
Right.
And your point is?
From what I read, his longtime girlfriend isn't even really truly represented in the movie, but there are these girlfriend-like figures that are a composite of multiple characters. So I don't think that, I'm not going to entertain this notion seriously, but it's kind of interesting to think of from a metaphysical standpoint. Could you be defamed somehow by omission? If you really are truly a part of a story, and you are absent from it, and whereas your presence in the story would have somehow validated, the reality of a situation, I think that would fail as a defamation claim, because there's no statement that would be of or concerning the plaintiff in that situation. But perhaps we could think, at least from a speculative standpoint, could that be harmful for one's reputation to not be mentioned in a story?
I love that idea. Yeah, this is going to be the commonly perceived history of Facebook, that you've been wrongly omitted from said history.
I think that that's Oscar Wilde's thing, that the only thing worse than being talked about is not being talked about.
Yeah, it's funny how prescient he was in that. I mean, hard to believe that was a 19th century guy saying that.
We are going to talk about the idea theft claim, no doubt, right?
Oh, well, we are now, Marty. Go ahead.
No, I mean, I'm afraid that this is the thing that's going to fascinate me the most about the movie, because this is, half of the people who come in the door are entrepreneurs who have an idea, and very often not the means to execute the idea, which sounds like the Winklevoss brothers in the movie. Just as a little background, for those of you who have been in a cave and don't know the genesis myth of Facebook, these two brothers at Harvard had the idea for a Facebook-like program, approached Zuckerberg, who had coding skills, engaged in some sort of contract, and several litigations later alleged that Zuckerberg stole the idea. And this is the nightmare of every entrepreneur. They come in, they can't completely execute the idea on their own, and they want to know what's going to happen if I tell my idea to someone talented, and they think to themselves, who needs you? So I don't know, is this going to drive more business to my door, people seeing this movie? Where I can say, don't let this happen to you.
Well, explain that, Marty. How could someone coming to see you specifically prevent this from happening to them?
They don't like my advice, because my advice tends to be more talented. Many people get ideas for a new product or what have you, and they don't often have the means of executing it, because they simply don't have the skill set, or they don't have all of the skill sets necessary to have an enterprise. And they go into an IP lawyer, and what we have in our bag of tricks are not necessarily adequate. We could have them write up the idea and obtain copyright protection. If they have truly invented, or at least if they have developed the idea to the point of patentability, then they can go to a patent lawyer. And then they always fall back to the weakest thing, which is non-disclosure agreements. And it's, at this point, fairly much the conventional wisdom that a VC or an angel investor or whomever is not going to sign an NDA because they hear ideas all day long and they simply can't do their job. And my advice usually is go out and, for example, before you take your meeting with the VC, go out and experiment. Go run it with a lot of tests. At least you have some trade secret information that you can keep to yourself during the first meeting. But again, this is the primordial fear of many entrepreneurs, that they disclose the idea and the person is going to say, who needs you? And as long as at the very core of copyright and patent law that pure ideas are not protectable, we're going to continue to see the Zuckerberg-Winklevoss fact pattern.
And
Marty,
complicating this whole...
I'm sorry.
Evan first, then Karl.
Okay. Complicating this whole dynamic even further is the resistance that venture capital types have to signing non-disclosure agreements, because they look at them as silly, and we could understand why they might look at them as silly or unnecessary, not only from a practical standpoint of the pain, the bothersome nature of having to go through this, but also just the resistance of wanting to obligate themselves to secrecy when they don't even know what the secrets are. A couple of additional points on this. I would commend to you something posted on theoatmeal.com this past week. I don't know if you're familiar with it. This is a comic. I think he's up in Seattle. Really entertaining little comics. Go to theoatmeal.com/comics/email. And from this past week is, if you do this in an email, I hate you. And one of these is a response from obviously somebody in the position of a venture capital. This is all satire. It's not real, but talking about, hey, I'm really interested in working with you. I can't tell you. Actually, this would be the entrepreneur writing to the venture capitalist. I'm really interested in working with you. I've got this awesome idea. It's so amazing, but you'd probably steal it. I can't even tell you that it is a project. For all you know, it's something intangible like love, gravity, or clouds. It's quite amazing. My uncle, I can't go on some of it's a little bit off color here, but there's that real resistance there with between entrepreneurs and venture and potential investors in signing these things, because they don't even know what they're getting into. The other point I wanted to make about this, which actually just kind of adds on to this, I heard Dick Costolo speak back a couple years ago. He at that time was with, I guess he was already with Google, but he's one of the founders of FeedBurner, and has recently, since then, just in the last couple of weeks, been named the new CEO of Twitter after Evan Williams has stepped down as CEO. I mean, he just really lambasted the whole idea of signing non-disclosure agreements, essentially just saying, if it's that great, if your idea, Mr. Entrepreneur, is all that great, somebody's already going to have thought of this. And, I would, venture to say that it's not going to be all that great to begin with when I hear about it. And don't flatter yourself into believing that I'm actually going to be impressed by anything you would say. So hell no, I'm not going to sign your non-disclosure agreement. That really makes it tough in our position as legal counsel of how to advise entrepreneurs to protect themselves when they have good ideas, and especially when they truly, legitimately want to have some protection, not just disclose it to the world. It's tough.
Karl?
I was listening, and I was going to jump right in and say, Marty, that advice, that be more talented, is worth the wait for the whole show right there. Tune in and get the one-line bit of advice that's worth everything. I think that's a big part of it, and I deal with this a lot of times where people will come to me and say, oh, I've got this unbelievable idea. Can I tell you about it? Can you refer me to someone that might be able to help put it together? And you're right, 9 out of 10 times more than that, it's something either or I'll email them and say, here, it's been done about 10 times and it's not good at all. Or, be more talented. I mean, I like that. Have some idea. Be a little bit more involved in the field that you're trying to break something out of to be so incredible. Already have some knowledge, have some ability, so you can at least do something and not, so many people think they'll just come up with this concept, this great online concept, and that's it. Now I just have to hand that unbelievable concept off to someone. I'll never do a thing again, and I'll just retire on that. And it's interesting because I've never thought of it from a legal perspective, but now that I'm thinking more about that, aren't all of these NDAs nothing more than just good ammunition to sue if somebody goes around you and does this on their own anyway? I mean, is there any actual protection from them doing anything with this information?
The ones I draft always have lightning bolts come out of the sky immediately if it's breached. You don't even have to sue.
Those are the really effective ones. We call those the Moses NDAs.
When I give the NDAs to the client, I say, I'm happy to charge you for this, but I want you to know that in 22 years as an attorney, I have never litigated an NDA case. They don't go to court. This is not your best bet. By the way, I need to point out that the Be More Talented admonition is not directed at my existing clientele.
That's good to know, Marty. Well, one of the things that Facebook has been quite talented about is the way that it has developed and is attempting, on a daily incremental basis to improve and advance its ad platform. And there is a rather incendiarily titled article, which I believe, I haven't seen the hard copy of the magazine, but I believe is the cover of this week's Business Week, called Facebook Sells Your Friends. And while it's not breaking any news there's no, particular recent thing that Facebook has done that is characterizable as selling your friends. It's a really lengthy, detailed overview of the Facebook ad platform. And so I stuck it in the links for today, which folks can check out at delicious.com/thisweekinlaw/81. Because it's for those of you who are interested in exactly what Facebook has done since Beacon, and you see those ads, but you're not quite sure how they're working and why sometimes they're off on the side and then other times they show up in your news feed. This explains and walks you through the whole process, and there's a nice discussion of how Facebook's ad philosophy differs from Google, and how here's a bit from the piece. Facebook's promise to advertisers isn't to get consumers to buy their products or really even to get them to click through to their website. Instead, it wants to subtly park the advertiser's brand in the user's consciousness and provoke a purchase down the line. More immediately, it also aims to get you to like the brand yourself, which then serves as a sort of all-purpose opt-in, allowing the advertiser to insert future messages into your feed. So I throw this into our Facebook privacy discussion, and I'll ask Evan first. Do you think that Facebook is doing a good job of meeting user expectations these days with its ad platform? And is it overcoming the various privacy PR problems that it's had in the past?
I just wonder if people tend to forget after a while about Facebook's privacy transgressions. It's been so interesting to see, since really since the launch of the news feed. And when was that, 2006 or 2007? We had Beacon in 2007, all these, various uproars that happen from time to time when Facebook makes some changes. So given the fact that there appears to be some fluidity in people's tolerance for how much Facebook is permitted to do, I don't know if we can objectively evaluate, at least evaluate effectively how well they're doing, because it's almost as if they just push the border so far and then retreat a little bit, and we just tend to deal with them here. If anything, they're at least doing a good job of giving privacy some lip service, making the ability to change your settings simpler and all of that stuff. Nothing is going to obscure the fact, though, that Facebook is in this as a commercial endeavor. They want to make money through advertising, and there's clearly a benefit into having more information out there, making it more social, having the graph be open and distributed across the web and all of that stuff. So there really will be nothing to take the place of common sense among the users and educating themselves about how their information is kept and where else it may be seen. So we just cannot let Facebook be the only one responsible for personal privacy.
Yep. Marty, any thoughts on Facebook ads and privacy?
Well, I mean, if I'm watching 30 Rock and there's subtle product placement, and it is that a violation of my privacy in any way? I mean, I've said it the last time I was on the show, and that is you just have to educate the public how to use the Facebook privacy settings a little bit better. That's pretty much all I'd have to add.
Mm-hmm. One thing that has happened in the last week that impacts on the Facebook privacy settings is it's rolling out of the new groups features. Groups have been on Facebook for quite some time, but now they do new things. They've sort of rolled in the whole Google Wave concept so that there's live chat among a closed group of people. The privacy complaints they've been getting about groups have to do primarily with people being able to form a closed group, but then any member of that group can invite someone new in. So that could rapidly get out of control. And one thing I've noticed is that even if you have your Facebook notifications fairly well tweaked, and again, we're back to the fact that it takes a lot to get through all of Facebook's privacy and notification settings, you wind up hearing from folks in a group that, in a way that is maybe too high volume for your preference. My email box right now is flooded with things I need to go through, and I need to go adjust those settings again, all as a result of groups having come out with these new features this week. Karl, are you finding that your privacy expectations regarding groups are not met? And what do you think of how Facebook's doing with its ad program?
Well, I actually tinkered with Facebook ads for my insurance business a few times, and it's always left me sort of waiting for something to happen. It's been less than stellar. I think the concept of this subtle placement, it's sort of like, well, okay, we know we're not going to get anyone to actually click on the links, so we'll just tell you that they're seeing it. It's getting in their head. After time, it'll get through to them. It reminds me of the mentality that the Yellow Page salesman has when he comes in and says, you might not get the phone ringing right away, but 3-4 years down the line, when they keep opening the book and finding your company in there, they'll start using it. As far as the groups goes on Facebook, I've talked about Facebook privacy till I'm blue in the face, and then they change it, and there's more to talk about. I think the whole concept of groups is doing nothing more than, you end up with so many people on Facebook, and you realize, I really don't want to talk to these people, and I really don't want them to see my kids' pictures, and I really don't want them to either. I have this problem because I have my insurance business, and then I have my writing business, and the blogging and all these other things, and they're very different groups of people. The problem is that basically I'm creating separate lives this way. I'm going to have, well, this is the internet people that I know, this is the family, these are the friends, these are the business colleagues, and before you know it, just like you're saying, Denise, you end up with more to deal with than less, because you've carved out all of these little individual niches of people, and then you have to, again, go through exponentially all of the privacy settings for each of those. And it could be a full-time job. I could literally spend a couple hours a day really granularly going through and checking to see what I want to allow, how I want to get notified, where I want to get notified, and that's just on the Facebook webpage. If I turn around and I go on my phone where there's a Facebook app, there's all sorts of other notifications and settings that we have to go through. I think the biggest challenge still is it's just very, very complicated. And if it's complicated as far as we're concerned, and when we play in this game, can you imagine what it's like for the average person that gets on Facebook because their friend said, "Oh, I posted some pictures. Go and have a look."
Well, it occurs to me that Mark Zuckerberg is in a very philanthropic and societally helpful mode right now. Maybe this is just his solution to the economic problems that we've been experiencing, creating new jobs in the form of privacy valets that could come to our aid in this way.
Good idea.
Hey, it's a create new job, right? Now everyone's a social media expert, and now all of a sudden we'll have a breakout from that. Some of those people will turn out to become privacy experts. And they'll be able to show you how to flip those switches for your privacy settings all over.
Absolutely. Well, I don't know if flipping any switch is going to help you if the government builds in a back door to your Facebook activity. And I want to talk about that and the proposal that's on the table along those lines. But first, I want to say thank you to one of my favorite sponsors on the TWiT network who is sponsoring this show, and that is Hover. Hover.com is a domain registration company, and it makes it all so simple. Now, you might think that all you could do at Hover is go and register your .com, .net, whatever you'd like domain, and certainly you can do that there. But what I really, really enjoy about the service is how easy they make it to customize your email. And in fact, there's a great blog post, and I'll stick it in our discussion points over at Delicious from last year, by someone at Hover named Michael, saying, yes, we can change our email addresses. And it goes through the various concerns people have about personalizing their email address. For example, for years I had an MSN, garbledy-gook initial number email address. And I'll never forget when Jason Schellen was over at Google at the time and sent me my Gmail invitation. I was so excited. And he prefaced it by saying, get yourself a real email address. So I could be dhowell at gmail.com. And that was certainly a step in the right direction. But it's still, not a fully customized email address that could go with me wherever my mail server might be. And Hover can do that for you. You don't have to start using a whole new email interface. You can use whatever web service that you love, whatever non-web service that you love. And there are tutorials there for how you can have a personalized email address tied to whatever email you would like to use. You don't have to tell everybody that you changed your email address. As soon as you start using your new address, that will be the address that they have for you. So you don't have to be adf37 at AOL.com. You can be, as I am now, Denise at Howell.net. Well, you can't be Denise at Howell.net, but you can be somebody who makes more sense for you. And Hover makes it really, really easy to do. So I want you to go over to hover.com, actually go to TWiL.hover.com, and you'll get 10% off your new domain or whatever other services that you use. And as you're getting set up over there, if you ever need to use customer service, they have a no-hold policy for customer service. I used it twice. It was excellent. I wasn't put on hold. I got a person who could walk me through exactly what I needed to do. I transferred some domains from GoDaddy. They have a whole tutorial on how you can do that because GoDaddy actually doesn't make it very simple to transfer out of their service. You get a live person who's very, very helpful, and it's a great experience. So go check it out for yourself at twil.hover.com. Don't forget to use that address to get your 10% off. So, folks, let's talk about the Obama administration's proposed backdoor into various web service, web communications platforms. One way of looking at this is that we're simply needing to update our wiretapping laws to take into account that the way that people communicate has changed. People only perhaps could use the phone and then email for their communications for several years there preceding today. And now there are a whole host of other ways that you can communicate: Skype, Facebook, IRC chat, what have you. And that those laws need to be brought up to speed so that there is not, you're not simply driving people off of one platform and onto another, and the government is left out of being able to do whatever investigations it needs to do when it has good cause to do them. Evan, is that the proper way to look at this, or is there something more dangerous at stake when you're talking about building in a back door that the government can access for services like Facebook?
Seems to be the biggest danger in all of that is if the back door is built but not properly secured, or doesn't have a strong enough lock on it, or is, we could expand the metaphor even more, saying, it's just weak and somebody could break right through it, and in turn cause more problems and more severe problems than those problems which are sought to for which a remedy is being sought. I'm glad we're talking about this issue so early on, because right now there doesn't appear to actually be any legislation that's been drafted. We're just kind of talking in generalities about something that the Obama administration may be proposing in the next few months. And so, the more that this can be in the public consciousness to talk about and think about between now and the time that there actually may be some legislation, the longer that time period is, the better off we are. It's a really important interest here, because I don't think any reasonable person will deny the fact that law enforcement ought to have reasonable tools available to it and the reasonable opportunity to track down the bad guys who may want to do us harm. In the same breath, you can't one cannot avoid saying that should not and cannot and shall not be at the expense of our civil liberties, and somehow encroach on the important privacy rights that we have. And so we don't want to, it's cliche, we don't want to be in this Orwellian society where the government is listening to everything we're doing and watching everything we're doing and getting into these back doors to accomplish that. So I think that the principled way of looking at all of this is to recognize the importance for law enforcement to be on a reasonable playing field, so that when they go about tracking Al-Qaeda operatives within the United States or communicating to the United States, those threats can be identified and dealt with without unreasonably expanding the authority to survey or to surveil, to listen in, to eavesdrop beyond those constitutional limitations that we are aware of. However vaguely from the body of jurisprudence that pertain to our individual privacy and freedoms in those ways. So it's got to be, like so many other things in the law and in policy, there's got to be a balance stricken here to the extent possible to be technologically agnostic, to not deal with, to not tie it down to particular technology so that the legislation will be obsolete, but to somehow keep up with the progression and the transformation in way communications are being made.
On this subject, we have a couple of comments over on our Facebook page where I post pre-show questions. You can check that out between the shows at facebook.com/thisweekinlaw. On this subject, Jason Watkins over there said, laws shouldn't be passed to make law enforcement's job easier. And Doug Hanchard has a pretty lengthy take on this proposed strategy. He says, though, is it a potential danger? Yes. Is it potentially in violation of existing U.S. laws? Yes. Can the collection of such information, voice or data, be abused? Yes. So it sounds like Doug is urging caution on these lines as well. Karl, what do you think about building in backdoors to additional types of communication services for the government?
Well, I can acknowledge the fact that it's obviously necessary that that there is some form of we do have to keep law enforcement does need to be kept on par with technology, even if it means the Great Firewall of China type of mentality. The problem is, and I'm all for having them have access where it is appropriate. I have several big concerns. My main concern is we see how government is run typically. I'm concerned about how that, as I think it was Evan mentioned, I'm concerned with how it would be actually put into practice and what type of technology would they be utilizing and how well would they be utilizing it to monitor traffic. What also concerns me, again, in the insurance industry, we have very specific privacy laws that we have to go by for health insurance and things like that. There's HIPAA and just a whole slew of them. And I'm wondering if there's this big back door where all traffic can be monitored, what happens to all of these existing laws that are in place to keep things private and to sort of compartmentalize different things and to keep them in their respective areas? How is that? That's a big, big undertaking to keep that clear and clean and correct. And again, leaving that up to the government is a concern, I guess, is the best way to put it.
Marty, any thoughts on this?
Well, I don't, again, have any special expertise on this, but I would be interested in hearing a fact pattern. But for this back door, what can't government do? I mean, if someone were to give the government probable cause today that they are a member of the Taliban in the United States, can't the government obtain various warrants to look at this information? So why this back door? Why is it needed?
Good question. Hopefully the administration and the New York Times, which I believe broke that this was on the table, will continue putting the issue in front of us before anything is actually proposed on the legislative front. So let's talk next, Marty. You had posted, and I've seen around the web, that there seems to be a new full text of the draft Anti-Counterfeiting Trade Agreement, ACTA, that has come to light. I haven't looked through it yet. Is there anything new and exciting there?
There's a couple of things we can talk about here. Some of them are of interest to me as in their esoterica relates to trademark and counter copyright law. We can talk about it in the way in which IP protection is treated in the media. That's another way we can go, because ACTA has received a somewhat similar negative perception as that recent COICA bill that
ACTA and COICA.
When you say it like that, it sounds like cloaca, which I think is the way a platypus lays eggs. So I think that's a very serious cloaca. That's the real word, folks. All right, so the Anti-Counterfeiting Trade Agreement, it is a plurilateral trade agreement, which means it's just a bunch of countries and their friends got together. And they have been negotiating, and they've had 11 drafts. They earned a lot of enmity by being fairly closed about it. I think drafts only began being leaked last year. But this time around, they had a news conference in Tokyo, I guess this past Monday, and they said, here is a draft, and that draft is available. We distributed the link in connection with the show. I personally believe that expedited resolution of problems like the DMCA and the UDRP and things like that, I think that they're fundamentally good things. And I was kind of hoping that ACTA would help harmonize world law, and there'd be more DMCA-like notice and takedown procedures. And I am already anticipating a backlash and saying I'm not talking about the anti-circumvention aspects of DMCA. I think they're problematic, and don't want to see them to become worldwide norms. The anti-circumvention provisions have been very watered down. I think that a lot of from a pro-free speech point of view, the worst aspects of ACTA have been removed from this draft. Wired ran an article by Professor Geist from Canada where he said something like, Net's worst nightmare removed from ACTA, and that is a fairly close read. Having said that, we have not really dealt with one of the pressing issues for IP protection on the internet, which is precisely what sort of liability should an intermediary, such as an ISP, have when a website is used to disseminate infringing material. So I think that's still an open question.
Okay, Evan, any thoughts on ACTA's latest iteration, or on ACTA in the backdrop of we talked about again a few shows ago, the situation in Russia and how intellectual property law could be used as a pretext to do things besides enforce intellectual property rights?
Yeah, I haven't looked at this most recent draft, and nothing has been brought to my attention to make it think that it ameliorates or reduces any of those problems that we'd identified before. And what we were talking about with the Russia situation there sounds a lot like perhaps on a grander scale, the notion of copyright misuse or something like that, using the force of law attached to intellectual property enforcement to achieve ends other than the protection of that intellectual property, and that problem just seems exacerbated to me when it's on an international scale like this. I guess the other point I have about ACTA, which is separate from that, I read something. It was probably over on Tech Dirt because Mike Mazdick covers this so closely. I think the Mexican Senate voted unanimously to against what would it be called, ratifying ACTA, not participating in it. So
signing onto it.
Right there, we have an indication that there could be a substantial economic participant, really showing some real resistance to this. So this is just
they're one of those axis of copyright evil companies, right? Or countries.
Yes, I guess so. And what ultimately is going to happen on this is probably anybody's guess. I think that the optimistic view is that things aren't as bad as what they seem, but we've got homework to do between now and when this really is going to be starting to be taken seriously.
Yeah, well, I'm actually kind of surprised. All the coverage I had read about it was that it was scheduled to be finalized and put out there for people to either accept or reject in September of this year. That doesn't seem to have happened yet. Marty or Evan, do either of you have any insight, or have you read anything about what the current status is for finalizing this thing?
Well, we have to add an important point in that in the United States, the administration has taken the view that this does not change United States law. And the implication of that is that, therefore, there's no congressional oversight. It can be enacted as an executive order. So I think that's a very important point to emphasize, that United States citizens will not have an opportunity to call their congressperson about this. So let's just state that from the outset. I suppose that you could go in, if you're motivated enough, go into court and say, this does vary United States law, and therefore the executive order is inappropriate. But let's get that on the table, that there will be no ratification by Congress in the United States of ACTA for that reason.
Well, let's talk too then about the other not international treaty, but proposed U.S. legislation that you mentioned, Marty, is not the process of a platypus laying eggs, but sounds much like it. COICA, or COACA. Anyway, it got tabled, as Evan let us know last week, and is not imminently in danger of being enacted without further hearings in the Senate. Mike Masnick had a great post about web blocking, ignoring various problems, not solving anything, and used primarily as a political tool. Do you have any thoughts on COICA, Marty? And do you think that, especially given your background as a trademark lawyer who's concerned about brands, this legislation, proposed legislation, purports to be able to kick brands entirely off the internet if the Department of Justice thinks that it is justified? Oh, are you muted, Marty?
Yes, I was. There's a machinery outside the office right here, and I was trying to mute that. Okay. As a matter of substantive law, this is not dream legislation. Dream legislation for me would be notice and takedown for trademarks. This has to do with identifying sort of like a 3 strikes you're out concept for domain names, and they'd go onto a blacklist. If you put Alibaba.com on a blacklist, that would have a meaningful impact on the flow of infringing goods into the United States and cause a trade war with China. So I think that if you had a true bad guy who's in some sort of haven and they're running a true counterfeit operation and they're using XYZ.com, so XYZ.com goes on the blacklist, so he goes out and he registers XZ something else.com. So it's a form of whack-a-mole. So as a effective form of IP enforcement, it is neither here nor there. I mean, there's certain situations where it'll be useful. What's more interesting to me is the way in which this bill got tabled in a week. There's a professor, George Lakoff, he talks a lot about language. He talks about framing, so that, in other words, by calling inheritance taxes a death tax, that affects how we feel about the entire issue. Within a day or two of COACA being disseminated to the public, it was framed as a censorship bill. TechDirt is, I read them regularly, they do great stuff. They made the point that the bill itself was disingenuous in that it conflates the terms infringement and counterfeiting. And with your permission, I'd like to go into a little bit about why that is disingenuous when true. Counterfeiting is an intentional crime. There's the intention to deceive someone through reproducing a trademark. Infringement is the overall term. All counterfeits are infringements, but not all infringements are counterfeits. Infringement is merely the adoption of a similar mark that causes confusion. It can be a strict liability tort. You do not intend to harm anyone, but if you cause confusion, it is the tort of infringement. One can understand heightened powers and ex parte powers to deal with the crime of counterfeiting. It is not as understandable to have these sort of heightened powers with regards to garden variety infringement. The name of the bill is Combating Online Counterfeiting and Infringement, or Online Infringement and Counterfeiting. And critics are correct. That is an impermissible or disingenuous conflating of two very different acts. On the other hand, it has now become not even worthy of mention that when critiquing IP proposals, to conflate IP enforcement with censorship. We understand, we've seen cases, Scientology is accused of utilizing IP laws to censor opposing points of view, for example. In politics, we're seeing an awful lot of DMCA action to silence perhaps other people's views. But it is simply not correct, and it affects the entire debate, to automatically conflate IP enforcement with censorship. And I don't think we're really looking at the merits of bills if we immediately say, this is a censorship bill, because they're not.
But it might be a side effect of the overarching enforcement goal.
Yes. The person who has had their content taken down can no longer disseminate that content in that way. So in that sense, that speech has been curtailed by the IP enforcement.
Right.
Whether that's the overriding goal of the act or the purpose of the bill, I'm not quite sure that's the case.
Yep. Well, we'll have to see what happens with it. The thing scares me. I look forward to the Senate having a full and thorough airing of all the issues on it before they decide to go forward.
Why does it scare you? Let's talk about your fears.
having a kill switch based on the fact that the United States controls the domain name registries and registrars of the world, the primary ones. It smacks me as a land grab, something that is based on happenstance and strategy, and not something that's really designed to address a problem. I mean, obviously, it's going to give a solution to a problem, but it seems to me a pretty sweeping solution that would not be accomplishable, but for the fact that the registries and registrars happen to be under our jurisdiction here in the U.S. So, it's clever. I'll give them that. It's certainly a novel approach. So that's why it scares me. We should go ahead, Karl. Comment?
No, I was just going to agree with you. And after I finally had a chance to write down my notes about the platypus, so I can impress my son tonight when I get home, I was listening very closely to what Marty was saying, and I was just going to agree with you. Actually, having summarized it, that I think there's a necessity for this, but I have a real problem with that overriding control being with one entity in the government like that.
Yeah. Hey, I have a couple of quickie stories just to highlight for you before we get to our resource and tip of the week. Karl, you sent in one about Apple being ordered to pay $625 million about a patent that purportedly relates to cover flow. Thank you for sending that in. That's a verdict out of I guess, a state court in Tyler, Texas. Now, that can't be. It's a patent case. So, but apparently...
Yeah, and if it's in Texas, it was probably filed last week. Isn't that one of the rocket dockets down there?
That's right. So I'm guessing it was a federal court in Tyler, Texas. But it's a, pretty big verdict there that, of course, Apple plans to fight. The patent at issue is from... Is it David Galertner's company? Who's a Yale fellow.
The best part about this verdict is that the U.S. Patent Office just issued and granted Apple a patent for cover flow day before yesterday.
Oh, that is the best part.
That they were just given, right? So it should be interesting to see how that works in appeal.
Yeah. All right. Well, good luck, Apple. And then the other thing I wanted to hit really quickly here is also on the patent front, Facebook was granted a geolocation patent that, although it's sort of late to the geolocation game with its Places service, this patent would, cover seemingly everything that Foursquare does, everything that Gowalla does, et cetera, et cetera. So this will be an interesting one to watch. Carolyn McCarthy has a post over at CNET on it at her blog, The Social. So my tip of the week this week is that if you want Google to get behind your piece of legislation that we have been talking about here, COICA, you don't really accomplish much by threatening them. So Eric Gardner, once again, has a post about can Hollywood get Google to support its new anti-piracy bill? Basically what's gone on here, Patrick Ross at the Copyright Alliance alludes to the fact that Google should really get behind this, so he says, because of its AdSense policies and how it enables people quite readily to put AdSense behind or next to, adjacent with, infringing or perhaps arguably infringing content. And this is an argument we've seen raised about Google before. As Eric says at the end, seems to be sort of a veiled warning in all of this. I think I remember in the Perfect 10 cases, there were some allegations that Google could be contributorily negligent because of the way that AdSense has run. Evan, any quickie thoughts on this? Do you think Google's going to get behind COICA?
I had never really considered how Google would fit into the analysis on all of this, and it's probably one of those things where Google could make arguments either way. I mean, clearly, it relies on the integrity of the infrastructure of the web. So, for that sense, it may not want the the domain name system being messed with, like what COICA it contemplates. But I guess, and we would need to kind of think this through, that it would bring it out from being stuck in a rock and a hard place on a copyright standpoint, wouldn't it? Because would it somehow legitimate its advertising efforts? I guess we just got to think that through a little bit. I don't know.
Well, I guess it would let Google off the hook, I think, is the theory, that if you could just, do away with the infringer, then you wouldn't have to worry about pursuing Google for also having ads on the site.
I see.
That Google would somehow be immunized, or the thought of its liability wouldn't even have to be considered then. So, interesting theory, but my tip is if you want Google to get behind your proposed legislation, the best way to do that is not by threatening them. And then finally, our resource of the week comes courtesy of Marty, and in connection with a story that came out this week that a lawyer was able to get a patent on his 16-second introduction to his podcast.
Trademark.
Oh, I'm sorry. Yes, a trademark.
He's a patent lawyer, though. That's important.
He's a patent lawyer. It was reported on Dennis Crouch's Patently O blog. But yes, that sound recordings can actually be trademarkable. And you have this great link I'd never seen, Marty, to the whole kids pages section of the USPTO. And there among the kids pages is a huge database of clips where folks can listen to a mark. You want to tell us about this quickly?
Well, the PTO has resources for kids because they think it's important that kids learn about designations of origin early in life. But they do have a page that's nothing but MP3s of some of the most famous sound trademarks. Can your engineer play a couple, or did we figure that out?
I didn't tee it up for him, but folks can check it out. I put it in delicious.com/thisweekinlaw/81. How many of these trademarks?
I can sing some for you right now, and you can see if your audience... Bum, 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 bum.
Yeah. What
I won't do is the Pillsbury Doughboy giggle. You know how the giant monster hand pokes the dough and then he giggles? That's the registered trademark. There you go.
The Pillsbury Abominable Snowman.
But you do record, everybody knows that sound.
That's right. So, yes, we haven't talked about whether the Ghostbusters folks got sued not just for, I guess, copyright infringement, but maybe trademark infringement when they made their movie. So that's fascinating. I thought it was interesting that the whole notion that marks could be trademarkable. And I guess the USPTO, as you say, Marty, wants kids to know about this from an early age because they have thoughtfully provided a whole database of them, sounds, scents, and other formats that cannot be represented by a drawing, but can be subject to a trademark. So thank you, Marty, and thanks to the USPTO. And with that, we'll go ahead and wrap up the show. I'll let you guys, if you have any final thoughts on anything we've talked about today. Karl?
Well, I have to tell you, it's always very educational when I get a chance to be on the show. I got to learn about copyright infringement, platypus, mating and laying egg habits. I mean, what more could I ask for, on a Friday afternoon? But I'm always happy to be here, and it is always a learning experience for sure.
Well, we have been pleased to provide the experience and really pleased to talk to you, Karl. Thanks so much for joining us. Folks can check out Karl on Twitter. He is Karl Wireless with a K. And Karl, you have your own podcast or more than one. You want to go ahead and plug those?
Sure, why not? I have a tech podcast at westsidegadgetguy.com, which is actually the name that is sort of my pen name. And then I think I have the privilege of being the only insurance-related podcast weekly over at susmaninsurance.com. And we have weekly video podcasts there actually talking about the status of the real estate market and the insurance market and some tips and tricks and things that go in there. And I think that is about it for the podcast for now, fortunately. Keeps me busy.
And the chat room is pointing out that in Ghostbusters, it wasn't the Pillsbury Doughboy, it was the Stay Puft Marshmallow Man. And my apologies.
I love that.
They're difficult to tell apart. Stay Puft versus Pillsbury Doughboy, round one. Fight, says Troubled. Marty, we really appreciate all your insights and thoughtfulness and helping us understand what's going on with a lot of important stuff. Thank you so much for joining us. You're muted, buddy.
Oh, just leave it like that.
We'll fill in for you.
No, I need to give all the plugs.
All right, do it.
All right. The microblog is at trademarkblog on Twitter. On the web, it's trademarkblog.com. And as a side hobby, I have a law practice in New York.
Awesome. And folks can go there and get such sage advice as be more talented. And which really, I mean, what better advice could you get from a lawyer? It's 3 words long. I don't know what you could really bill for that advice. And it's so valuable. So just one of the many bits of wisdom you could get from one Marty Schwimmer, and we're happy to have passed an hour or so in your company. Thanks so much.
My pleasure, Denise.
And Evan, wonderful as always to have you back on the show.
Yes, great to be here. Had a wonderful time. Thanks for having me. It's a great way to spend a Friday afternoon.
Evan is perpetually blogging about important developments in internet law at internetcases.com. So between the shows, do check him out there because he's got wonderful and breaking news-oriented stuff.
Yes.
And of course, he's also at Internet Cases on Twitter.
Right, and
Thanks,
be sure to like Internet Cases on Facebook, facebook.com/Internet Cases.
Ooh,
Go on over there
and do that.
And like it.
Yes. And with that, we Keymasters are out. Have a lovely weekend all, and we'll see you next week. This is TWiL, This Week in Law, episode 81. Yes, let's just leave it at that.